a substantial prison term attached to these. In our conversations, Mr. Lugenbeal did and repeatedly expressed accountability and wanted to resolve this case with a plea, did not want to take this matter to trial. And one of the primary delays, and again, there's no sort of imputation of error, but the state was filing additional charges. And then afterwards, we were waiting on an offer of resolution. Mr. Lugenbeal is amenable to treatment. He has expressed several times wanting to make a positive change and to move forward from this behavior. Certainly recognizes that this is wrong, and testing these materials does create an indirect form of harm when those are accessed or disseminated. With regards to the California allegations, Your Honor, these are in essence identical allegations encompassing the same course of conduct while the California investigation was ongoing and before Mr. Lugenbeal was actively contacted. He did effect a move up to the Washington area. So this is not a pattern of behavior in which Mr. Lugenbeal is engaged in additional criminal activity. It again is substantially the same. The final request that we would make of the court, Your Honor, is that we would ask the court to release the digital storage drives after more or less being sanitized and not be forfeited. And the nature of that request, Your Honor, is that these are the only source of a significant amount of photographs, which have enormous, obviously, value to the family. And if these drives are otherwise destroyed or forfeited, as is normally the case, that would result in the loss of those images. So again, Your Honor, we would ask the court impose that 57 months with the understanding, again, that there are 36 months of community custody to follow that, and that he would be subject to sex offender treatment, of which Mr. Lugenbeal has repeatedly indicated that he wishes to undergo, and that's underscored in the PSI.
Mr. Lugenbeal, is there anything you want to say before I sentence you?
Yes, I'd just like to say that I, of course, am very sorry for what I did, and I have no intention of reoffending, of course, and I'm open to treatment, and I'm going to try to make the best out of this situation, and I'll accept whatever the court gives to me.
Whoever's saying hello and everybody else on the Zoom conference, mute your microphones. You're not involved in this hearing. You're interfering with the record. Sorry, Mr. Lugenbeal. Were you finished?
Okay. Yes, that was it. Thank you.
All right. Well, the court had the opportunity to review the materials and in the file and the state sentencing memorandum and everything else related to sentencing. I'm not sentencing him with regard to anything related to the California case. I'm focusing solely on the materials that were here in the state of Washington and Mr. Lugenbeal's activities here. Those activities, the number of people victimized and the length of the number of images involved is more than sufficient to justify a high end of the range. I'm sure he was anxious to get this resolved, because certainly the state, based on these images, could have exacted a much more severe punishment. This case went to trial. So the 75 months is appropriate. Sentencing him to 61 months on each count 1 and 2, 75 months on count 3, followed by 36 months of community custody on the conditions outlined. Because of his length in custody, I'm going to find he's indigent and only impose the mandatory minimum legal financial obligation. I wish I could impose restitution for the many young people that Mr. Lugenbeal victimized, but unfortunately that's not something that's possible because of the nature of the victimization. With regard to his request regarding the hard drive, prior to the state destroying hard drives, they can notify Mr. Lugenbeal or his counsel. He'll have 120 days to post sufficient funds and to propose a person who can go into the hard drives and retrieve non-offensive materials. But the cost of doing that will be his, and he'll need to do it in advance. If he doesn't do that, then the materials will be destroyed.
Thank you, Your Honor. And I would note the DNA fee is mandatory. This is a first felony conviction in the state of Washington. There's also $2,000 of possession of depictions fees that are also mandatory in this case, Your Honor.
Okay, $500 victim assessment, $200 criminal filing fee, $100 DNA collection fee, and $2,000 fee for depiction. All will be imposed. I'll advise you at this time that you have the right to appeal your conviction and the right to appeal a sentence if it's outside the standard range. If you do not file a notice of appeal within 30 days of today's date, you will lose the right to appeal forever. The Superior Court clerk will supply you with the notice of appeal form upon request and file it upon completion if your attorney will not assist you with those matters. You have the right to have the cost of the appeal paid at public expense and an attorney appointed to assist you at public expense if you cannot afford those things yourself. And any petition or motion for collateral attack on this judgment or sentence, including but not limited to any personal restraint petition, state habeas corpus petition, motion to vacate judgment, motion to withdraw guilty plea, motion for new trial, or motion to arrest judgment must be filed within 1 year of the final judgment in this matter, except as provided for in RCW 10.73.100 and RCW 10.73.090. And because this advisement follows a guilty plea, your right to appeal is limited. Do you understand that, sir? I will also advise you, I'm sure they did at the change of plea, but because I was not present, I will want to make sure that you were advised that following conviction, you may not own, possess, or have under your control any firearm, and under federal law, any firearm or ammunition, unless your right to do so is restored either by the court where you're convicted or the Superior Court in Washington State where you live, and by a federal court if required. If you have a concealed pistol license, you must immediately surrender it. You understand all of that?
Yeah.
I've signed the documents to reflect my ruling. They'll be sent to you directly. Your attorney's not here to review them in person, so the court will send them to you for review and signature and for prints, and that'll conclude the matter.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Terry, do you have the Joner matter?
I do.
Is it ready to proceed?
It is.
Are you David Franklin Joner?
Yes, sir.
What's your date of birth?
10/24/63,
What grade did you complete in school?
12.
Can you read and write the English language?
Yes, sir.
Been handed a statement of defendant on plea of guilty. Did you read that form?
Yes, sir.
You understand everything that was in it?
Yes, sir.
Have you had enough time to talk to your attorney about how you want to proceed?